The Healthcare Labyrinth Podcast is back for another episode. Join Marc S. Ryan, a veteran health plan and health technology executive, as he explores the world of healthcare.
Welcome, everyone, to this edition of the Healthcare Labyrinth Podcast. My name is Marc Ryan. It's a pleasure to be hosting, and thanks to everyone for listening in. I wanted to put in a quick plug for two series we've done on the podcast. One was about health plan economics, and the other was about my modest healthcare reform proposal and some deep dives into the three tenets I have of healthcare reform, which are price reform, universal access to coverage, as well as pivoting to care management. So these two series, about 4 podcasts each, can be found at your leading podcast apps and sites or at the Healthcare Labyrinth website by hitting the podcast tab. Today, we are tackling another rather complex issue. And on June 28th, a Supreme Court case involving what is known as Chevron Deference in the regulatory and rulemaking process was decided by the Supreme Court. This Chevron deference dates back to 1984, and essentially the court overruled its precedent on this issue. So that is always controversial. This impacts laws and regulations and rulemaking, so this will have far-reaching impact, especially on healthcare. So I decided to tackle this subject in the podcast today. We're going to try and break it up to make it a little easier to understand. We're going to start out with a brief intro and an overview. We'll take a quick break. We'll go deeper into the decision after that. We'll take another break. We'll tell you next where I stand on the overruling of the Chevron deference precedent, and then we'll take a last break. And then I'll sort of wrap it up about what it all could mean for healthcare and stakeholders and things like that. So let's get into a couple of quick topics here just to sort of have a baseline of understanding of the actual decision. So I first want to talk about rulemaking. Well, what is rulemaking in and of itself? Well, it's basically when the executive branch publishes and ultimately promulgates regulations, in this case, in the Code of Federal Regulation. And what rulemaking does is it implements various laws that are passed by Congress. And so rulemaking is a very, very important part of the overall process. It is sort of the details in the explicit rules, so to speak, of the law that was passed by Congress. Now, not every law necessarily has rulemaking, but the vast majority of them do. And this is how essentially government works. And this is how stakeholders in the community, say corporations or even individuals, interact with the government within the bounds of laws, which are sort of set out in explicit detail in rulemaking or regulations. Let's talk a little bit about the roles of the three branches of government in the so-called law and rulemaking process. Well, again, if we go back to our grade school here, we know that there are three branches of government: the executive, legislative, and judicial branches. Well, each of them sort of has a role here. Number one, Congress will pass laws. Obviously, it's the only branch of government that can do so. The president and the executive branch can recommend laws, and a president often sets an agenda for Congress. But ultimately, it's up to Congress, the legislative branch, to pass laws and essentially create public policy, in essence. Next, let's talk about the executive branch. So I told you that the executive can recommend new laws or changes in laws, but the primary function of the executive branch is to implement the laws and run the government. And so that's where rulemaking comes in. Within the cognizance of the executive branch, they promulgate these rules and regulations at each of the agencies. And that sets the path for implementation of laws and enforcement of laws, which is another role of the executive branch. Lastly, we have the judicial branch. The judicial branch is, of course, the entity that interprets whether laws were implemented correctly and whether a given law passed by Congress may be unconstitutional and things like that. So, in fact, Chevron touches on this issue of what branch of government should be interpreting the acts and laws of Congress. Should it be the executive branch or should it be the courts? Now, as you'll learn later, I think both branches of government have some sort of role in that. But the Supreme Court in the Chevron decision clearly attempts to take back that interpretation of law back to the judicial branch that it, through the Chevron Deference case, actually ceded some, and actually some would argue a lot of control over to the executive branch's rulemaking process. I would also note that another key point here is that the Chevron Deference, although this is a healthcare podcast, obviously, the Chevron Deference decision, say that 3 times, has impact across all agencies of government and for policy making in all areas. So this is not just a healthcare decision. This impacts environment, healthcare, consumer protection, commerce, taxes, and much, much more. And so that's your brief overview of rulemaking and things like that, and the branches of government and the role in rulemaking. Now, I want to cover one more concept here, which is the concept of Supreme Court precedent. So a Supreme Court precedent generally is a major decision made by the Supreme Court that is meant to essentially establish court policy on a given topic. It could be procedural, it could be a topic area, and things like that. And these precedents tend to guide lower courts' rulings. And generally speaking, precedents stay around for a long time, and the Supreme Court is usually not really willing to overrule precedent very often. Precedents have been around for decades, and they have guided lower courts' rulings in whole vast areas of the judicial system for years and years and years. However, in more recent years, as the court has become more conservative, now with what you would say 5 to 6 strong conservatives, and now with just 3 liberals, the Supreme Court has more and more begun to strike down precedent. Good example is the striking down of Roe v. Wade in the last couple of years. And Chevron is yet another example of striking down precedent. So the court struck down the Chevron deference precedent that had guided lower courts' interpretations of how they should decide on challenges to the rulemaking and different rules out there. It was around since 1984. So it was around for about 40 years. And now suddenly the court has come back and said the new court believes that the Chevron deference should be struck down, the precedent removed, and now we have a whole new way of thinking about rulemaking and how laws are interpreted by executive branch agencies, and now the courts will take on more and more role here. So let's keep going here. Our next topic here, just on background, is essentially discussing sort of what is Chevron in itself back in 1984. So as I indicated, by a vote of 6-3, the Supreme Court justices overruled the landmark 1984 decision in Chevron versus the National Resources Defense Council, which gave rise again to the doctrine known as the Chevron doctrine or the Chevron deference or the Chevron precedent, depending on who you talk to. And so this was very much expected, frankly, because Chevron had begun to being chipped away by the Supreme Court. But the Supreme Court did rule that 1984 deference under the nation's regulatory system is no more. It is now thrown out. The precedent is out. And it's clearly a very technically complex ruling that has major implications, as I noted, for policymaking throughout government. And again, as I noted, Chevron was not just a precedent for healthcare, but across all government agencies. So what is the Chevron deference and what does it mean? Well, the Chevron deference is referring to the doctrine set out in the Supreme Court precedent that stated that judicial deference, that's where the word deference comes from, is to be given to executive administrative action. So why is it called Chevron? Does it mean that it's an insignia, for example, on a uniform? No, it's not that. It's not a rank either. But it is indeed named after the famous Supreme Court case in 1984, Chevron versus National Resources Defense Council. And Chevron USA was one of the actors in that case. And Chevron USA, as most of you know, is the big oil producer, supplier, and retail, one of the major oil companies and energy companies in America. Its roots go back to 1911. John D. Rockefeller actually controlled Standard Oil at the time. And so Standard Oil was the big oil company monopoly. And the Supreme Court in 1911 determined that John D. Rockefeller of Standard Oil ran afoul of the Sherman Antitrust Act of 1890. It's interesting that this is the second time that I'm talking about the Sherman Antitrust Act. In a recent blog, I talked about a Blue Cross and Blue Shield Association antitrust lawsuit that was recently settled based on the Sherman Antitrust Act of 1890. So this act that encourages competition in the economy, is still around over 100 years later, and it's doing its job. So again, Standard Oil, Supreme Court ruled the monopoly violated the Sherman Antitrust Act, and in 1911 it ordered the breakup of Standard Oil. And the breakup actually occurred into 34 companies. One of those companies was Standard Oil of California. They sort of kept the name Standard Oil, but they were freestanding entities around the country. And so Standard Oil of California came out of that breakup. And today, that company is branded and known as Chevron. And again, it grew up over time to be one of the biggest oil companies today. So again, Chevron versus National Resources Defense Council was decided in 1984, actually on June 25th, by the Supreme Court. And the case concerned a disagreement over a charge in the Environmental Protection Agency's interpretation of a permitting provision of the Clean Air Act amendments of 1977. So basically, Chevron, the EPA, the Natural Resources Defense Council were in this case. Chevron was challenging a permitting provision. The NRDC, a famous environmental activist nonprofit, was involved. And again, the EPA was involved as well. And the case questioned how federal courts should view a federal agency's interpretation of a statute that Congress directed the agency to implement. So as we know, laws are not all-encompassing. Sometimes laws run hundreds, if not thousands of pages, but they certainly do not have sufficient detail to actually be implemented in everyday life. It's up again to the executive branch to implement them, and that's where the rulemaking process comes in. But in this question, the Supreme Court held that federal courts should defer to an agency's interpretation of a statute under these circumstances. Those two tests are essentially, the court said, lower courts, you need to abide by an agency's regulation as long as, one, it met Congress's clear intent, and number two, if there are ambiguities, that the rule was reasonably constructed. It was not arbitrary, capricious, or just contrary to the statute. So that gives executive branch under the original Chevron deference decision great latitude. And so as long as they're acting in good faith and not unreasonably, and they're meeting the intent of Congress, they essentially cannot really be questioned under the original Chevron deference decision. I will note that later on, Chevron was narrowed on a few occasions by the Supreme Court. So again, this decision to overturn the precedent was not unexpected. One Supreme Court decision held that only the agency interpretations reach through formal proceedings with the force of law, such as adjudications or notice and comment of rulemaking for the Code of Federal Regulation, qualify for Chevron deference. Opinion letters, policy statements, agency manuals, or other formats like that did not count. So there had to be some formality related to the decision by the executive agency. In previous rulings, the Supreme Court issued guidance also related to what is or is not ambiguous. The court ruled in 2022 that regulators must have clear congressional authorization before acting on major questions, because agencies were sort of going outside the rubric of Chevron deference and actually using underlying statutes to make major decisions that Congress had not acted on. Lower courts have been moving in the no Chevron direction in rulings over the past few years as well, which sort of has led to this landmark decision. So we arrive at 2024, 40 years after the original decision, and the Supreme Court has now overturned the Chevron doctrine in a case known as Loper Bright Enterprises versus Raimundo, holding that it was inconsistent with the Administrative Procedures Act and gave unelected government officials too much authority. Before we take our break, just let me underscore here, Chevron was one of the most important principles in administrative law for 4 decades. And the fact that it has now been overturned in one fell swoop really is going to create huge issues in the rulemaking world. And so when we come back from the break, we'll give you a little more details about some of the thoughts and the rationale of the justices in deciding to overturn Chevron on a 6-3 vote.
The Healthcare Labyrinth is no ordinary website. It features news and commentary from one of the nation's leading healthcare policy and technology experts. Marc Ryan combs the internet for the latest healthcare news and publishes a news feed each weekday with summations and Marc's insights. Twice a week, Marc publishes a blog to go deep into a current issue. And of course, Marc hosts a podcast each week to delve even further. All of this is available at healthcarelabyrinth.com. Visit each day for the latest happenings in healthcare. As well, learn more about Marc's book, The Healthcare Labyrinth, at the website. That's healthcarelabyrinth.com, your go-to source for healthcare news.
Welcome back. We hope you're enjoying this episode of the Healthcare Labyrinth Podcast. We've been talking about the Supreme Court's ruling on Chevron and the ousting of this administrative rule precedent related to the executive branch agencies, giving them great flexibility within some constraints to essentially interpret laws that are otherwise perhaps ambiguous. So again, the court in June overturned the Chevron doctrine in Loper Bright Enterprises. So proponents of Chevron deference, before I get to the opinion of the justices, really felt that Chevron deference is a necessary power of regulatory agencies. They say its elimination will lead to a wild west of court decisions in the future, with courts in various regions, some liberal, some conservative, having different approaches to interpreting laws and how laws should be carried out. They argued that agencies are really the policy and regulatory experts, and the discretion was best held by the agencies. Most proponents, too, support Chevron because it has allowed agencies to be activists in nature and push the limits of certain laws. What might not be able to be passed by Congress actually gets through regulations under Chevron. Democratic administrations and those aligned with Democrats are really known to like Chevron because it promotes that activist agenda. Opponents, more Republicans, I would say, and more, strict constitutionalists argued that Chevron backfired and created an administrative state that is far reaching and one that went well beyond the Supreme Court's original intent. They say that regulations went well beyond legislative intent as well. So both the Supreme Court's original intent and legislative intent. Opponents believe that Chevron led to policy changes, sometimes big, when administrations change. So regulations were put in place and then other administrations came back in, whether Democrat or Republican, to reset the stage. And this upset the regulatory landscape for stakeholders who could not rely on regulations once they were passed and issued by one administration when they were investing in their businesses. So let's talk about the 6 conservative justices and the 3 liberal justices. So number one, as you can imagine, the 6 conservative justices basically recounted much of what the opponents said. So number one, the 6 conservative justices indicated that, again, over the last 40 years, the Chevron deference went well beyond what the Supreme Court intended. They were very concerned that many of the agencies were getting into policy making, which they viewed as the cognizance of the legislature, and were essentially passing laws through regulations. They also felt that as a new court, that they had to return to the original pure constructionism of the 3 branches. And the 6 conservative justices basically indicated that it is the job of courts to interpret laws. And if they have to go into the granularity of regulations, they will. And that it was not correct or appropriate for the previous court 40 years ago to actually designate vast amounts of law interpretation to the executive branch agency. Well, the liberal justices, of course, believe that this is going to just break down the entire regulatory system and that the 6 conservatives were basically upending the entire regulatory process of America. And they basically indicated that they felt, again, that this Wild West phenomenon would occur and that courts would be striking down left and right. There would be different interpretations in courts. The Supreme Court will now have to get into all of these different discussions and arguments, and that public policy will be hurt because implementation of laws will take far too long or will be challenged and essentially never implemented. So that's basically the 2 sides, both from a public policy perspective as well as from the justice's perspective. What will all this mean? Well, one important point is that most regulations that have been overturned in the courts in the past many years really have had little to do with Chevron. Most of the court actions overturned portions or all of regulations tied to the fact that agencies often blatantly ignore legislative intent. They overstep their regulatory authority or ignore their very own regulations and the Administrative Procedures Act in the process when they're promulgating regulations. So there's a good amount of history in recent years that agency rulemakers are bad actors. When there is clear intent of Congress, they are not following it, or they are really, really overstepping even beyond the bounds of Chevron, their authority to promulgate certain policies and regulations. This will create major issues moving forward. There's no question. Regulations will have to meet a much higher bar. While judges had to defer to agencies short of clear direction from Congress, now the courts will scrutinize such regulations. Court reviews will take significant time. Even more regulations will now be struck in whole or part, and enacting regulations generally will take far more time. More time for initial promulgation, court study and decisions, and likely second, third, and more rounds of amended regulations. Policymaking will become far more incremental than activist. Wide-ranging regulations in all walks of life will be the exception and not the rule. Regulatory agencies will have to approach complex policies over a series of years and regulations, sometimes even waiting for Congress to weigh in more than once on matters. I will say one thing that the Supreme Court made clear is the majority said that the High Court was not intending to overturn prior regulations that relied on Chevron. But there is no doubt in my mind that many previous rulings could be revisited and litigated again. With that, we'll take our next break and we'll be right back in a moment.
Lilac Software is proud to work with the Healthcare Labyrinth website to educate people on the healthcare system. At Lilac, we believe transparency is so important in healthcare. The healthcare system is opaque, and Lilac is trying to bring clarity to data and unleash the best member care, reduce costs, and improve outcomes. Our cloud-native payer platform revolutionizes data insights and analytics. Plans have all the data they need, but in silos locked away in point solutions. At Lilac, we solve the data fragmentation problem and help plans turn complex data into actionable insights, leading to greater operating leverage, tight cost controls, and healthier members. Health plans can improve STAR scores, reduce medical expense, drive revenue, and more. Quite simply, with Lilac, you can drive better business and health outcomes. Learn more at lilacsoftware.com.
Welcome back, everyone, and thanks for listening in to this Healthcare Labyrinth podcast on the Chevron Deference decision. I promised you to tell you where I stand on this ruling, and to be honest, I'm not totally sure. As someone who served in government, I tend to think about a few things that really mean that executive agencies should have some discretion. And let me list some of those here. So number one, again, executive branch should and must have some discretion in how they implement laws. In my years as a executive branch official in state government, I know that as much as I respected my lawmakers, they are notoriously sloppy in how they enact laws. They simply do not give enough details, and the lawmakers and their aides are just not the experts that they need to be, and they cannot prescribe meticulous regulatory details or oftentimes give sufficient direction for promulgating regulations. I would argue, again, the lawmakers are not the experts, and they oftentimes are happy to delegate some deference in terms of carrying out and implementing the laws to the executive branch. I do not doubt that the agencies have expertise, and I very much doubt that judges somehow are the experts. They would have to become experts on everything, including even emerging technologies such as AI, something Justice Kagan raised in her dissent. I have seen plenty of cases in my service in state government where judges just clearly got it wrong because they were not the experts and they did not understand nuances or details. Judges are not supermen or superwomen just because they went to law school. Sometimes incrementalism in policy as well will mean important issues grind to a halt. And my fear is that what we will see here. Now, I am not someone that believes in activist regulatory agendas because I think that's bad. But I also believe that incrementalism sometimes kills good policy. And that could very much happen here if policies take so much time to be implemented through regulation because now we'll have cautious regulators, active special interests challenging things, and this increased court scrutiny. So that's a little bit of a concern of mine. I just spoke about special interests. The thing that I fear most about this ruling is that these special interests will now seize on the expanded ability to sue to essentially stop any reasonable policies from moving forward. And I think that would be a shame. On the court side, I really wonder if courts are going to get overwhelmed sorting out all the issues and conflicting rulings. And more importantly, will the Supreme Court then get overwhelmed and have to weigh in on all the conflicting decisions at the lower levels? The Chief Justice argued in his opinion that this is in fact already occurring today, but I am just not sure he understands the magnitude of the impact that could occur. Now, let me go to the other side of the issue. At the same time, as a former executive branch official in state government, I know firsthand a few things, and this is where I may agree more with the conservative majority. An administrative state can become extremely unaccountable and essentially seize policymaking from not only the legislature, but the executive branch itself. I saw this firsthand. I became very concerned that my administrative state and my state essentially took away my power as an executive branch appointed official. There's good reason to think that this indeed is what happened since Chevron became the rule back in 1984. Chevron Deference, in essence, built the administrative state. Agencies, principally under Democratic administrations, use Chevron to enact sweeping and broad policy changes, sometimes by relying on underlying statutes. And I think the conservative majority has a good point here. Regulators, I also believe, should not be absolute policymakers per se, but implement policies set by our elected leaders. Too many regulators view themselves as more important than those lawmakers. There's no question that agency bureaucrats at the federal and state levels often have become activists and have an activist agenda. The decision in Chevron could actually as well give stakeholders impacted by federal agency regulations a fighting chance now, a chance that they probably didn't have before. As an example, most stakeholders lack the resources or sophistication to fight back on unfair regulations issued by agencies and clear due to Chevron deference today. Yes, big companies fight all the time, but there's a whole lot of little guys, small businesses, medium-sized businesses that don't have resources or sophistication to fight back, and therefore their businesses are hurt, or they potentially even go out of business because of unfair, onerous, sweeping regulation. In the future, perhaps courts could stand as advocates of the stakeholders and strike down regulations that are too far-reaching, too onerous, and beyond what laws clearly intend. So how do I sum up my pros and my cons here? Well, in a nutshell, I wonder if the Supreme Court ruling was a bit too far-reaching and unwieldy. While it had already reined in Chevron to some degree, could it have attacked additional concerns a little more incrementally, targeting the remaining egregious examples of overstepping Chevron deference without throwing out the precedent entirely? With that, we will take our last break and we'll come back and tell you what the implications are for healthcare agencies, as well as healthcare stakeholders.
Health plans and insurance are confusing. Our healthcare system is in dire need of reform. Health policy expert Marc Ryan tackles both issues in his book, The Healthcare Labyrinth. It is both a guide to navigating health plans and fixing American health insurance. Marc dives deep into how health plans and the American health insurance system operate. He then outlines a comprehensive reform agenda for the system as a whole, including pricing, emphasizing health and care management, and ensuring affordable access to health coverage in a private delivery model. Marc is a bit of an unconventional Republican in that he believes affordable access is the morally right thing to do, and that it is also fiscally prudent for our nation. Learn more about Marc's book, The Healthcare Labyrinth, at healthcarelabyrinth.com or search at leading bookseller websites. Available in print, ebook, and audiobook forms.
Welcome back, and we hope you're enjoying this episode of the Healthcare Labyrinth Podcast and our discussions on the Chevron precedent being thrown out by the Supreme Court. So I promised you to sort of sum up here and really talk about what will happen on the healthcare front. Well, as I've sort of alluded to in general in terms of regulations and what will be the fallout, in general, less healthcare policy will result because Congress as the lawmaking body, the agencies as the implementing body, and courts as the interpretive body will all need to adjust and likely go far more slowly. It will take much longer to implement regulations successfully, and such regulations will be less activist, less far-reaching, and more incremental. Healthcare agencies undoubtedly will be heavily impacted with regulatory delays and potential court actions due to the complexity of the regulations they have, and frankly, the money at stake for providers, plans, drug makers, and more. Some speculate that healthcare agencies now will rely on sub-regulatory processes, non-binding guidance, and enforcement actions. But this has its own risks too. Indeed, after losing numerous court cases on several issues over the years, the Centers for Medicare and Medicaid Services limited their use of some of these sub-regulatory processes because they were already vulnerable in court. So I'm not so sure that will be an answer to agencies' problems. What will happen in healthcare agencies proper? Well, perhaps the biggest impacts may be seen at the Food and Drug Administration, the FDA. Regulatory efforts, especially those impacted by emerging technologies and new scientific evidence, could be stalled as courts sort out challenges. Drug approvals might also be challenged. We will also likely see even more challenges to the Department of Health and Human Services and CMS's regulations. Healthcare parties will challenge the myriad financial and policy regulations issued even more so than they did before. This could be the case with rate setting as well. You should also expect to see far less activist regulations on Medicaid, Medicare, exchanges, and more. Some of those areas were where CMS and HHS really rolled out regulations that perhaps were not governed strictly by new laws, but underlying statute. So some of this will be reined in for sure. What will happen to healthcare stakeholders? Well, providers may see more harm than benefit given how reliant they are on regulations, especially rate setting. But radical changes such as staffing mandates at nursing homes, as an example, which is very controversial right now, may be less likely in the future. Health plans and pharmacy benefits managers may benefit a bit, as efforts to enact radical changes will become less likely, although they'll be out there, and rates that they rely on need annual notices, but not necessarily in-depth regulatory changes. Drug makers likely will be hurt by a slowdown in the FDA regulatory process, as I noted, but they could benefit from the backburnering of things like expanded drug price negotiations. Now, that's one that I feel bad about because I believe in that, but I think the Chevron Deference precedent being thrown out will empower drug makers to challenge incremental expansions along the way of the Medicare drug price negotiation law. With that, we hope you enjoyed this rather arcane and in-depth analysis of the Chevron Deference precedent being thrown out. And we'll see you next time on the next Healthcare Labyrinth podcast. Take care.
Thanks for joining Marc and the Healthcare Labyrinth Podcast. Go to healthcarelabyrinth.com each day for the latest healthcare news. See you next week on the next Healthcare Labyrinth Podcast.